State your name.
Charles Drago, D-R-A-G-O.
And what is your occupation, sir?
I'm a police practices consultant.
And you have your own business?
Yes, I do.
And what's the name of that business?
It's Drago Professional Consultants.
If you could, for the arbitrator, describe briefly your area of specialty.
I specialize in, I offer my services to police departments in the general area of management and organization, but I also offer my services to law firms to consult on matters of use of force, patrol procedures, pedestrian stops, traffic stops, vehicular pursuits, and generally in those areas.
And what length of time have you been operating this business, Drago Professional Consulting?
About 3.5 years.
Now, what I'd like to do is have this marked as Union 17. There you go. I know you have a copy, but would you pass those along? Sir, I show you the documents have been marked as Union Exhibit 17. Do you recognize this document?
Yes, sir.
And what is this document?
It's my CV.
I'd like to have this moved into evidence as Union 17, please.
Can I proffer on it first? This first time I had a chance to see this. Sir, did you prepare this?
Yes, I did.
When did you prepare this? What we see in front of us?
This one is from October 25th, 2014.
Okay. And so we see here your professional experience in law enforcement, and it looks like you have a number of media interviews. Your media interviews, were those interviews as a result of your professional consultant business?
Yes, sir.
I mean, I'm going to go through this in some detail.
Well, why don't I do this? Let me reserve my objection, and I'll listen to you, and that may resolve it all.
Sure.
You know,
Okay.
So.
Sir, what I'd like you to do is turn your attention first to your education, which is going to be on, looks like it starts on page, well, starts and ends on page 4 of the document.
Yes, sir.
Now, please take us through your educational history, and what I'd like you to devote more time on, perhaps, is the Command Officers Development course that you graduated from in 1995.
Well, I went to the Broward County Institute of Criminal Justice, where I attended the police academy back in 1975. I have an associate's degree from the University of New York in criminal justice. I have a bachelor's degree from St. Thomas University in Miami in administration of justice, and I attended the Southern Police Institute Command Officers Development course from the University of Louisville, Kentucky, which, as it indicates on there, is a 400-hour, 10-week program for police executives.
And what were the types of subject matters that were covered during the course of that 10-week program, sir?
It covered police management, police operations, patrol operations, police deployment. It covered case law in terms of traffic stops, pedestrian stops, vehicular pursuits.
Use of force?
Use of force, all areas of policing and the management of the various units within a police department.
Did any part of that training course deal with the topic of how to appropriately conduct an internal affairs investigation?
Yes, it did.
Now, is that sort of a, I have to phrase this other than this way, was that sort of a plum for you to be able to attend this seminar?
Yes, there's basically two schools recognized around the country as the primary police commander schools. One is the FBI National Academy, and this is the other one. This one is a lot more expensive since the FBI Academy is free, so it is a plum when you get selected to go to this, and then of course you have to be accepted by the University of Louisville for the program.
And did you have to take any form of examination as part of this class?
I don't. At the end?
Yes, sir.
Yes, we did.
And I trust you passed it successfully?
Yes.
Now, let's go through your employment history if we can. And I certainly want to go over every aspect of it, but I'd like you to focus in on, if you could please, the management positions that you held and the roles that you held while roles that you held and participated in when you held those management positions.
Let me start at the beginning? Or?
Yes, sir. Please.
I started with the Fort Lauderdale Police Department and went through the ranks of the police department. That would be sergeant. As a sergeant, I was a road patrol sergeant, uniformed road patrol for a number of years. Was then the street narcotics sergeant for 5 years. I ran a county-wide street narcotics unit for 2 or 3 years, all as a sergeant. During that time, I was also an instructor. I trained officers in narcotics investigations and narcotics. I was then promoted to, or I was also assigned and worked as the homicide sergeant for a number of years. Was then promoted to the rank of captain. There were no lieutenants in the police department. Was promoted to the rank of captain. Served as a captain in the road patrol uniform division. Also, as a collateral duty, I was in charge of the field training officer program. When police officers graduate from the police academy, they're sent to an advanced training called the field training officers program. And in that program, they ride with a police officer who is called a field training officer, who gives him that advanced training where it's more hands-on than the police academy was. And he does that for a number of weeks, 14, 16 weeks, depending on the program. I was in charge of that program and also wrote the program for the police department.
What program is that?
The field training officer program.
Yes, sir.
Every officer has to go through that after he graduates from the academy. While in that program, the officers are taught all the policies for that police department, reinforcement of anything they learned in the academy, including the use of force, pedestrian stops, traffic stops, vehicular pursuits. It's an advanced training for everything that they learned in the police academy, and then some, because they'll be facing things in that program that they did not face while they were in the police academy.
Let me stop you at the police captain element, if I can, and that was for Fort Lauderdale Police Department.
That's correct.
Now, you said that while you held that title, you wrote the field training program for the department, yes?
Yes.
And elements that included appropriate use of force.
Yes.
And elements also included, if I'm correct, appropriate encounters with citizens, appropriate police stops, lawful detentions.
Yes.
Did you also, as the captain, did you specifically perform the training or any of the training for the officers? Not necessarily as an FTO, but performing training seminars as a police captain for officers on the topics of use of force or appropriate detentions, lawful stops, while you were with Fort Lauderdale in that role as captain?
As a field training officer, I did. Mm-hmm. As a role of captain, I did training for the field training officers themselves, but not for the officers.
So you trained the trainers?
Yes.
You trained the trainers on the use of force and topics like lawful detentions, appropriate traffic stops, that sort of thing?
Yes, we'd have periodic reviews of the material that we were training the officers in, and that was my job to maintain, to make sure that that was current and they were training the right materials, etc.
Was part of your responsibility in that position as police captain and as essentially, for lack of a better word, the overseer of the FTO program, were you responsible for keeping abreast of current legal developments, case law, for example?
Yes.
Or changes in statutes dealing with use of force or appropriate encounters with citizens, appropriate detentions, and other matters to make sure that your training program reflected the current state of the law?
Yes.
And you held that role for 5 years, and then you're about to say, I think, that you were promoted to major. I'll let you go on from there.
Yes, then I was promoted to major, and that position is the city of Fort Lauderdale is divided into 3 districts, and I was a major in charge of each district. A district being a geographical area within the city. I was in charge of that for a 24/7 period of time, of all the road patrol, of the uniform officers within that district. Part of that job is also to oversee any misconduct from the officers that is not given to the Internal Affairs Division. So any complaints on police officers that didn't rise to the level of Internal Affairs, the investigations were handled in the district, and the major was in charge of overseeing or reviewing all those misconduct complaints that came on his officers within that district. Part of the function of the major in that position.
Again, let me stop you there, if I may. And what types of police misconduct issues would come across your desk as the major during that period of time?
They would be anything from discourtesy to minor excessive force cases, to traffic accidents, anything in those areas.
Would it also include whether or not a detention was proper or improper?
Yes.
And would you be responsible for would you be a decision maker in those cases?
I'm
Go ahead.
sorry.
Please.
I would make a recommendation to the assistant chief, who then conferred with the police chief in terms of the findings.
Now, do you still have an FTO trainer role and the role of a major?
No.
Okay. But you still, in order to perform your job functions, kept abreast of the current state of the law when it deals with use of force or appropriate detentions, appropriate traffic stops, the full gamut of police activities?
Yes.
And that was in part necessary because you were responsible for receipt and handling these complaints that didn't rise to the level of IA involving police misconduct.
That's correct.
I'll let you go from there.
I served in that position for a number of years, and then was promoted to assistant chief of police. And in that function, oversaw the city of Fort Lauderdale is broken up into 3 bureaus. One of the bureaus is the operations bureau, which is all the uniform personnel. So I was the assistant chief in charge of the uniform personnel within the agency, and as such was also in charge of reviewing all the misconduct complaints that were received by the police department and make the final recommendation to the chief of police as to the findings. So any investigation, any complaint that came through the police department that was investigated by the police department, whether it be by the shift or whether it be through internal affairs, were all ended up on my desk where I would review the misconduct for their recommendation.
And again, these misconduct allegations would involve the very same topics we spoke of before: alleged unlawful use of force, alleged improper detention, the full gamut of police activity.
Yes.
And now, and you would make the final recommendation to the chief about what should occur.
That's correct.
In that case. Now, in that role, would it be your function to examine whether the internal affairs investigation was conducted in an appropriate manner?
Yes.
Did you also have that role as police major?
Yes.
So in both your role as major and assistant chief of police, you would not only be responsible for making recommendations to the chief based upon what you saw in the investigation about what discipline was appropriate, but you'd also examine whether or not the internal investigation was carried out in a manner consistent with best practices.
Yes, because what you did was you approved that investigation. It was complete and thorough, followed all necessary procedures and protocols before you ever passed it on to the assistant chief.
And there were circumstances where you would see an IA and feel that perhaps it wasn't, it could have been, issues could have been better explained, certain details were omitted, there were certain inconsistencies that might have been present, You would then send that back to the investigating officer, the IA personnel, to have it re-examined or somehow corrected?
Yes.
Now, did you ever specifically, as Assistant Chief of Police, would you directly supervise the IA personnel?
The IA captain reported directly to the chief of police, but the IA captain would submit any investigation to me, and we would confer on any investigation that was done within the police department.
Before it went to the chief?
Before it went to the chief.
And then how many cases did you, roughly, I'm not going to ask you to give me a specific number, but and how many cases do you think you performed this function?
Just as assistant chief?
Well,
or
let's go
throughout my career.
Throughout your career.
It would be in the hundreds, but I don't know.
Okay. And then, how many officers, it probably says it here, but how many officers were there in Fort Lauderdale?
About 600.
And again, as a part of your role as Assistant Chief of Police, you would keep abreast of current developments in police law.
Yes.
Correct. And how would you do that?
Many ways. One way was we had regular training programs to do that internally within the police department to make sure we stayed in touch with changes in case law and so forth. We had a legal advisor unit that would also confer with us on a regular basis to make sure that we were staying up to date with case law, etc. I belong to associations that would also help us stay in touch with changes, what was new in case law, International Association of Chiefs of Police, local Chiefs Association, etc. So it was an ongoing, constant process. We attended training sessions and training wherever we felt necessary. In Florida, all officers, certified officers, are required to go through mandatory retraining every 4 years. Some of that is updates on issues and policing practices. Other things are left up to the police officers to pick on their own. They just need to have so many hours, and so we can utilize those hours to keep abreast with all changes.
Now, while you were Assistant Chief of Police at Fort Lauderdale, would you take the information that you gathered from these different training sessions and these other sources, and then upon reflecting upon what was important and what wasn't important, would you then pass that on to the field training officers to make sure that the programs at the Fort Lauderdale Police Department abided by and were consistent with current field standards?
Well, depending on the rank I was in, I would certainly pass that on to the officers that reported to me. Sometimes they bring back information to update me on current changes, etc. When I was the field training officer commander, yes, I brought that back to the field training officers to ensure that they had the information.
Now, let's move on to your time at the Oviedo Police Department as Chief of Police. Please describe your role there.
I was the Chief of Police in Oviedo, which was a day-to-day oversight of the police department as a full-service police department. In the role as a police chief, of course, I had the final responsibility for what occurred within the police department. Also, the final responsibility in determining sustaining or not sustaining and finding fault with police officers in terms of misconduct and any citizen complaints regarding the police officers. Also responsible for all the policies and procedures in place within the police department.
You held that role for about 3 years.
Okay.
All right, and since that point in time, I see you still hold your law enforcement certificate, yes?
Yes, I'm a reserve with the Broward County Sheriff's Office right now, and by doing that, I maintain my certification with the state of Florida, and in doing so, police officers are required, as I said before, to attend mandatory retraining to maintain their certification. So by maintaining my certification, by staying as a police officer or a certified police officer, I also have to go through all the same training that every police officer in the state of Florida goes through in terms of that mandatory retraining. So that keeps me current still with any changes in the law, any changes, updates in police practices, etc.
Let me turn your attention, please, to page 5 of your CV. And it's going to be at the very top there where it talks about the role as a police instructor, and it does indicate former police instructor. Please take us through that element of your experience.
I was a certified, Florida Department of Law Enforcement certifies people to be police practices instructors in the state of Florida. I was a certified instructor for many, many, many years. I'm not certified any longer, I let it lapse. But I was a certified police practice instructor for many, many years and trained officers in various areas, including narcotics investigations, search warrants, high-risk entries, use of force, patrol procedures, including pedestrian stops, and programs for police officers in street-level narcotics investigations. I also was the only instructor in the Broward County Police Academy for all the narcotics instruction in Broward County. So every police officer that went to the police academy in Broward County sat in my class, which was on narcotics investigations, narcotics identification, recognizing substance abusers, substance abuse, those types of things. I trained all through that period of time.
Any guesstimate, and I know you said many, many years, but any guesstimate how long you served as an FDLE instructor?
I'm going to guess about 15 years.
All right. Now,
I still do training today, even though I'm not a certified FDLE instructor. I still do guest instructing for the Valencia State College, as well as for Seminole State College in their criminal justice program on various topics, including use of force, ethics, police, community policing, etc. And do training programs around the country. Next week I'm doing a training program for a college in Pennsylvania on use of force, police use of force.
While you were an FDLE instructor, did one of the topics that you would provide instruction on include lawful detentions?
Yes.
Did you ever provide any training to anybody on the topic of how to appropriately conduct an internal affairs investigation?
No, I don't believe so.
Now, let's move on to your role, your most recent role as an expert and a consultant in the field of police practices. I'm going to have this marked as Union 18. Sir, I show you a document that's titled Past Expert Witness Testimony. Do you recognize this document?
Yes, sir.
And what is this? Can you explain to the arbitrator what this document is?
Yes, this is a list of the cases in which I was retained and then testified either in deposition or trial as an expert witness.
Now, is this list up to date?
No.
Okay. Through what period of time does this list take us?
There's probably another 4 or 5 to add on here.
Okay.
3, 4, 5.
Any of those 4 or 5 involve trial testimony?
Yes.
What was the most recent case in which you testified at trial?
Yesterday I testified in a trial.
That's right.
In Monroe County, a criminal trial.
And what was the subject matter of your testimony?
It was pedestrian stops, techniques, use of force.
So were you certified by the court as an expert in this subject?
I was, yes.
Now, I'd like to have Unions 18 introduced as evidence, please.
We don't object to this.
Now, briefly, could you please go through and highlight to the arbitrator the cases in which you've been recognized as a court, by a court, as an expert in any field of police practice, but concentrating on use of force, lawful detentions, appropriate internal investigations, those subject matters.
Sure. Just go down the list.
If you can,
Point 'em out.
yes.
The first one is Bodden v. Deputy Cole. That was a use of force, officer-involved shooting.
You say it says testified in deposition there.
Okay.
What I'm looking at is the ones where
Just
you were at trial. You were recognized by the court to be an expert in some area of police practice.
I understand.
Concentrating the use in the areas of use of force, lawful detentions, appropriate internal investigations.
I understand. Number 5, State of Illinois versus Minders. That was a use of force case involving taser and hard hands techniques. Testified in trial and certified as an expert in use of force in that case. State of Florida versus Smithy was a criminal trial, a use of force firearm case. Testified in the trial, and that one certified as an expert in use of force. Murphy versus the City of Birmingham, Alabama, use of force, firearms, and hard hand controls.
And that's number 7.
I'm sorry, that's number 7. Certified as an expert, testified in trial in that one. Number 13 was Smith versus Sherry Appledorn. That was a use of force case, taser and hard hands, and I was certified as an expert in use of force in that. It was a federal trial. I testified in trial.
And also, that case also involved investigative detention. What do you mean by that?
Stops, pedestrian stop.
Whether it was appropriate?
Whether it was appropriate. Yes.
Okay, go ahead. Looks like the next one might be number 19.
Number 19, State of Florida versus Juan Camano. This is a use of force case, investigative detention, and hard hands control. Testified in the trial and certified as an expert in that case.
And again, that involved, whenever you use the phrase investigative detention, you mean to say that, or tell me if I'm wrong, that the subject matter that you testified about was whether the police had adequate basis in order to stop, detain, or question a citizen.
That's correct.
Okay. 19, and I believe the next one looks like this number 29, but tell me if I'm wrong.
No, I think you're right. Next one is Brown versus Orange County Sheriff's Office. This was a use of force case. Again, investigative detention, pedestrian stop. Testified in the trial, and that was a federal case. Certified as an expert in that case.
Okay, and then most recently was yesterday when you were certified down in Monroe County.
That's correct.
Expert in use of force. I would like to proffer Mr. Drago as an expert in the fields of appropriate use of force, appropriate police detentions, and appropriate conduct of internal investigations.
I object to it. There's no need to declare this witness as an expert in this proceeding. In criminal matters, in court of law, in order for him to render opinion testimony, he has to be declared an expert witness. That doesn't exist here. All these law enforcement witnesses have been freely giving their opinions on what's proper and what's not proper. And, in this instance, to the extent that he has the relevant knowledge of what happened here, I don't know what he's reviewed yet. He's got an opinion on that. I'm not going to object to that. I haven't objected thus far. But to the extent that the union is trying to declare him as an expert witness to give some sort of superpowers over the other law enforcement witnesses, there's no need to do that here. So we object.
The arbitrator can decide what weight he wants to give to the testimony, but the question remains, should he be declared an expert or not? I think that has absolutely no effect on what weight Mr. Prosper decides to give the testimony. He could decide to choose to give more credence to your witnesses, or he could choose to give credence to him. It's his discretion, and we should be limited in having him declared as an expert based upon this thesis basis.
I do agree with Mr. Blitchus in your discretion to describe how much you believe this witness or not, there's no need to declare him as an expert witness for you to do that. You're going to
That's
hear
his-
his testimony and see him. And
That's his entire purpose here, is to be certified as an expert in these areas. And there's nothing in the rules that he's cited or that exist that preclude this procedure.
there's actually no reason. The only reason that you declare someone as an expert witness is in a court of law, so that they can render opinion testimonies. There's no need to do that in arbitration proceedings. So the only reason they're offering him as an expert witness is to give him some superpowers here that you don't need to give. You can listen to his testimony and determine whether you believe his testimony or not.
He's saying there's no need, but I haven't heard him say that it's not appropriate.
It's not appropriate for an arbitration proceeding because
I'm sorry. There's absolutely no rule, no case that precludes the entry of expert testimony in an arbitration. That's what we seek to do, and that's what we would ask you to declare to be.
Okay, I will declare an expert witness, but he has no more power than anyone else testifying, but based on his resume, I take that into consideration.
Very well. Sir, have you developed opinions in this case?
Yes, sir.
Okay. And what have you reviewed in reaching your opinions?
I reviewed a number of materials that were provided for me, including some policies of the Daytona Beach Police Department, including the arrest policy, the oath and ethics, traffic stops, citizen contacts, search and seizure, non-deadly use of force, deadly use of force, the complaint filed by Ms. Chippewa, internal affairs investigation involving Officer Booth and Mr. Palmer, several various case law to include Foxhall v. Florida, Golphin v. Florida, Schmurder v. California, Nebraska v. Harris, Arizona v. Lewis. I also reviewed a treatise written by Mr. Michael Brave on the subject of swallowing cocaine, suspects swallowing cocaine in the interaction with police officers. I reviewed the Florida Department of Law Enforcement basic law enforcement curriculum for the police academy, which instructs officers on how to deal with these issues. The police incident reports of the officers involved. The memo to the chief of police from, and I'm sorry I didn't write down his rank, Mr. Kramer, Sergeant Kramer. Termination letter written by the chief of police, and IACP policies regarding these issues of citizen complaint and use of force. IACP is the International Association of Chiefs of Police, which is an organization made up of police commanders and police chiefs from around the world. They also have been given the authority by the U.S. Department of Justice to form the National Policy Center for the country. And what that means is that organization brings police chiefs together from around the country and formulate model policies. And the purpose of these model policies is to be available for police chiefs when they write their policies, that they can use them, they can take from them. They're not obligated to put everything that's in there, but these are best practices that have been put together in these model policies for the purposes of sharing with police chiefs around the country. And they are put together by chiefs from all over the country, so it gives a good mixture of police departments. It's not just one state or one area. It comes from all over the country, so it's on a national best practices level, and police chiefs will use them when they write their policies or formulate procedures in policing. And that's the International Association of Chiefs of Police, commonly referred to as IACP.
Yes. I heard you mention the internal affairs document. By that, do you mean the somewhat voluminous internal affairs document, which has as attachments the internal affairs statements, the narrative supplement report, the incident report, the arrest report, those documents?
Yes, all the statements of the officers.
Okay, that was all
involved.
included in the packet that you
Yes.
reviewed?
Yes.
Now, did you review any videos in relation to preparing your opinions?
I did. I viewed 2 videos taken from a body camera at the scene.
And the first video depicted just a simple, what amounts to a question and answer session of Ms. Chippewa. The second video was a depiction of the attempt to take Ms. Chippewa into custody.
I object. He's leading this witness. I'm giving him substantial latitude, but that's
We're
improper.
running out of time, Mr. Wood. I'm just trying to speed things along.
I've given you latitude all day, but this witness he's presenting
All right,
as an
fine.
expert witness.
That's fine. What did the second video depict, sir?
The first video was Ms. Chippewa sitting in her car while the officers spoke with her. The second video showed Officer Booth with Ms. Chippewa on the ground as they placed her under arrest.
Okay, very good. Anything else you can think? Oh, did you speak to anybody other than me? Did you speak to anybody in preparation for your testimony?
Yes, I did.
Who's that?
I spoke to Officer Booth.
Did you speak to anybody else? Now, what opinions have you reached in this case, sir?
Want to just go through the list of them right now, or you want to go one by one? Or how-
Well, let's go one by one.
I've come up with a number of opinions regarding this issue. The first one is that both contacts, Officers Raynham and Booth, made with Ms. Chippewa were lawful and consistent with police best practices. The police officers had reasonable suspicion for an investigative stop and reason for concern about her well-being. However, the contact was actually consensual and the officers didn't need either. So that's my first opinion.
Okay, let me stop you there. Now, the first encounter, why do you say that was an appropriate encounter of Ms. Chippewa?
The first encounter was when the officers first met underneath the bridge. A police officer has a right to stop and detain someone. I mean, there's really 2 cases where a police officer can detain a person temporarily. One is a traffic stop where the officer needs probable cause, and the other one is where the officer just has reasonable suspicion. And reasonable suspicion can be anything that officer can articulate as to why he was suspicious. It can't just be a hunch, but it can be anything he can articulate as to why he was suspicious. In this particular case, a female in a car at wee hours of the morning, I think it was 3 or 4 o'clock in the morning, whatever it was, wee hours of the morning, under a bridge where people usually aren't at that time, would make an officer at least pay attention, because an officer knows that that could be a number of things, and there's reason to believe that could be a number of things. That could be a female that's in trouble, simple trouble, like she's lost. But that could be something more serious, like typically narcotics deals will be done that way in secluded places under a bridge. Prostitution will be done that way under a bridge. People who are committing other crimes, burglaries, etc., at that time of hour could be there under a bridge. So there certainly was reasonable suspicion for the officers to approach her.
For the first time?
For the first time. In addition, the officers had a concern for a woman who was in the middle of the night sitting in a car in the dark underneath the bridge. Officers aren't just crime fighters. Officers also have a duty to protect the public and take care of the public and help the public. So a woman sitting in a car by herself in the dark under a bridge in the middle of the night, a police officer would be obligated. I don't think anybody would argue with a police officer be obligated at least to go and talk to that person and make sure that she's okay. That's a consensual stop. Officers can do that anytime they want, anywhere they want. They don't need probable cause. They don't need reasonable suspicion. They can just walk up to somebody and talk to them. That person doesn't have to respond. That person doesn't have to give them any information. That person doesn't have to stay there. But if that person voluntarily stays there, wants to talk to the officer, or allows the officer to talk to him or her, It's a consensual stop. So the officers had an obligation, in my opinion, to make sure that that person was okay in that car in the middle of the night. We want our police officers to do that. So the officers had reason to go and do a well-being check, as it's called or referred to that first time. So they had reasonable suspicion. They had an obligation to check her for well-being, and they could have done a consensual stop because you can go up and talk to anybody at any time. So there was more than enough reason for those officers to make that first contact.
Why do you say the second encounter was also appropriate?
In the second encounter, the officers acted properly in the first encounter. They decided that they didn't see anything that made them any more suspicious. Ms. Chippewa said she was okay, she was out of gas. The officers decided there was a police issue there, so they left in a very short period of time, which is the proper way to do it. They didn't detain her on any lengthy time, so they left, and they went back and they went over and they talked by their cars. While they did this, Ms. Chippewa started to act in a way that caused them notice. That being the doors opening and closing, lights going on and off, her flailing her arms inside the car, moving around in strange ways. Again, that would raise suspicion of a police officer, to give him reasonable suspicion to believe maybe we missed something, maybe there's something going on in that car, maybe she's trying to warn somebody that is committing a burglary nearby, or she may be in medical distress. And again, they have the right to do a well-being check, to go back and make sure that she is okay, that she doesn't have any medical issues. And again, they have a right to go back and do a consensual contact with her again and talk to her again. Say, are you still okay? We see what's going on in the car. Are you sure you're all right? Is there anything the police can do to help you? Do you need an ambulance? Whatever the case may be. So again, they were well within parameters of an investigative stop, a well-being stop, or a consensual stop in both encounters.
Now, in the second stop, what do you think the earmarks were of a consensual stop?
That she was not detained. They asked her questions. She voluntarily answered. They never made her stay there. They didn't do anything that would make her feel like she had to stay there. In other words, the police officers didn't have spotlights shining in her eyes, didn't have their overhead lights shining as she stopped and had to stay there. They didn't speak to her in a way that would make her feel like she can't go anywhere, that she has to stay. They weren't commanding or demanding. They asked her for things, and she voluntarily gave it to them. She has a right to refuse, but she never did. She has a right not to give it to them. She gave it to them. She answered every one of their questions and cooperated with them whenever they asked her any questions. So they gave no indication at all that she was not free to go.
Do you see anything in the records that you reviewed that suggested that she desired to leave?
No.
Anything that you reviewed reflect that the officers made any attempt to somehow box her in so that she couldn't leave?
No, and those are some of the things the courts have looked at in the past and that I look at when I'm looking at a case to see if there's any kind of subtle things the officer may do that would make a person feel like they really can't leave it if they want to. And those kinds of things are where officers might box them in. Officers got to have their lights on with their spotlights on them. There's 3 or 4 or 5, 6 police officers standing around the car, so the person feels very intimidated, very afraid to refuse the officers. None of that existed here. The officers were actually very, very hands-off, approached in a very courteous way, and didn't give any indication of that, of any force or threat whatsoever that would make her feel like she could not leave. They didn't. There was nothing that I saw in the record.
So to you, both the first and second encounters are perfectly appropriate police practices?
Yes.
Now, if you remember from the documents, when the officers initially approached Ms. Chippewa, she told them she was out of gas. Do you recall that?
Yes.
And when the officers approached a second time, she told them something like, "You're not going to believe this, I'm not really out of gas. I just forgot to push the clutch in." Do you recall that?
Yes.
Now, what, if anything, do you think was appropriate for the officers to think or believe at that point she uttered those words compared to what she had said during the first encounter?
Well, these are the kinds of things that occur during a police officer, pedestrian, or investigative stop, or a consensual stop. Any kind of stop, contact with a citizen, is as you engage in conversation with that person, things happen, the person says things that might cause the officer to become more suspicious, or start to become suspicious if he wasn't in the beginning. So when people change their story, say one thing, I'm out of gas, which being out of gas is pretty hard not to know if you're out of gas. And then to say, oh, I have plenty of gas, but I didn't know how to push in the clutch or didn't push in the clutch. So that would make any reasonable police officer wonder why she's changed her story like this. Maybe there is something here that we're missing, and continue to stay. And then, again, they've got reasonable suspicion if they want to do an investigative stop, or they can continue to talk to her because it's a totally consensual, voluntary interaction at this point.
Do you feel that from the point she made that statement until some other point in time, that the detention, strike that, did the encounter remain consensual? Or do you, am I asking, you understand what I'm trying to ask? After she tells them that she's out of gas, I believe Officer Random says, well, you know, what's really going on here? Or perhaps, do you have anything illegal in the car? At that point, do you believe that that encounter was still consensual?
Yes.
Once he starts to ask those questions?
Yes, it is, because again, she does not have to answer those questions. If she refused and they continued to pursue her with that line of questioning, that would be different. That would be investigative. But if they can ask her questions all as long as they want, and if she's ready and willing to answer them, it's voluntary. It's still a consensual stop at that point.
Now you said there's some
Consensual
cases.
interaction.
You said there's some cases that you reviewed in preparation for your opinions. Are any of the cases that you reviewed relevant to this issue of consent or the reasonable suspicion issue?
Well, the most prominent case, of course, that we're all familiar with, or police officers are certainly familiar with, is the Terry v. Ohio case, which establishes that you need reasonable suspicion in order to do investigative detention. In that case, that case has been around for a very long time and set up the facts of what reasonable suspicion is, and the fact that police officers need reasonable suspicion for an investigative detention, not for consensual interaction, and not for a police check.
How about the issue of consent? Is there any particular case that you relied on there?
In Golfin v. Florida, the courts found that an officer has to make a person feel like they can't leave in order for it to be a seizure or a detention. That basically, as long as she is consented to the encounter, and she consents by staying there and not trying to leave, as long as the officers don't do anything to make her feel like she can't leave, that it's a voluntary, consensual contact.
Did you see any indication in the materials that you read or the videos that you watched that suggested that Ms. Chippewa desired to leave, or was attempting to leave?
No.
Now, at what point during the course of the encounter, the second encounter, do you believe this became non-consensual, that this became a custodial, for lack of a better term, situation?
When Officer Raynham saw Ms. Chippewa take drugs and put them in her mouth, and he put his hands on her.
Okay.
At
So
that point, it was no longer consensual. She was not free to go. That's when it changed.
okay. So up until that point, you believe that the second encounter was consensual?
Yes.
And you also believe that reasonable suspicion supported the officer's actions had consent not existed?
Yes.
Now, what is your second opinion, sir?
My second opinion is the force used by Officer Booth when he attempted to prevent Ms. Chippewa from swallowing the drugs in her mouth was objectively reasonable based on the totality of the circumstances.
And you understand that the force utilized included the insertion of a flashlight and also included a knee strike to the head, correct? And let me just ask you the question. What force do you understand was utilized by Mr. Booth during the course of the second encounter?
He placed a flashlight in her mouth and put his fingers inside her mouth. In this opinion, I'm addressing just that portion of the force, not the kick to the head.
Yes, sir. Okay. All right. You also understand that in addition to, and perhaps it might be part of a subsequent opinion, does your second opinion encapsulate Mr. Booth's decision to use sort of a pinching move on the other side of her face to keep her mouth open?
Yes.
Yes, because that's also encapsulated within the second opinion? Okay.
Yes, it is.
And you found it was objectively reasonable under the circumstances?
Yes, sir.
Please explain to the arbitrator what observations, facts, law support that opinion.
When we look at a use of force, we follow law which tells us that whenever we look at a use of force by a police officer, we have to look at it through the eyes of a reasonable police officer based on the totality of the circumstances as the officer saw it at the time. What would be reasonable? What would a reasonable officer say or do under those same situations? And so you look at that particular case in the totality of the circumstances. You can't look at it in 20/20 hindsight with knowledge that we found out later on. We have to look at it based on the knowledge the officer had at that moment that he used the force. In this particular case, the officers were faced with an individual that they believed had drugs, cocaine, placed in her mouth. They're faced with two issues at this point. One is the danger to the individual of swallowing cocaine that can be injurious to a person, depending on how much is in there. It's a lot to consume for one human being, depending on how much it was. There's also an issue with the baggie that the cocaine is in. People have suffocated and died when they try to swallow baggies of drugs. So people have died from that. It is a danger to that person. So the officer is faced with that, as well as the fact that she is committing a felony in his presence, that being destroying, tampering with evidence. So the officer has to make the decision, a very quick, split-second